there is a temporary restraining order enjoining and restraining the petitioner and respondents from the sale or disposition of any assets of Lighthouse except in the ordinary course of business. This order also requires the petitioner to maintain the funds of Lighthouse on deposit in the Harris Beach LLP trust account. There is no written agreement submitted by the parties entitled an operating agreement. Therefore, petitioner concludes that Lighthouse is not a limited liability company, but instead is a partnership, that he may elect to terminate the partnership, and that such withdrawal of Spires from the partnership dissolves Lighthouse pursuant to partnership law section 62. Petitioner's legal argument is without merit. There is no provision in the limited liability company law imposing any type of penalty or punishment for failing to adopt a written operating agreement. The statute does not require an operating agreement prior to the formation of this type of entity. There is no statute or common law that leads to the conclusion that the failure to enter into an operating agreement transforms a limited liability company into a partnership. The limited liability company law sets forth when this type of entity is formed. A limited liability company is formed at the time of the filing of the initial articles of organization with the Department of State, or at any later time specified in the Articles of Organization. This filing of the Articles of Organization shall, in the absence of actual fraud, be conclusive evidence of the formation of the limited liability company as of the time of filing or effective date if later. A limited liability company formed under this chapter shall be a separate legal entity, the existence of which as a separate legal entity shall continue until the cancellation of the limited liability company's article of organization. The verified petition has a copy of the articles of organization of Lighthouse attached as an exhibit. There are no allegations that the articles of organization were not properly filed with the Department of State on or about November 11, 1999. Further, the attorney for petitioner concedes that the petitioner does not contest that Lighthouse Solutions LLC was formed as a limited liability company by the filing of the Articles of Organization. Pursuant to LLCL, Section 203, Lighthouse Solutions LLC was formed at the time of the filing of the Articles of Organization of Lighthouse Solutions LLC with the Department of State. According to the statute, the filing is conclusive evidence of the formation of the limited liability company, and it shall continue as a separate legal entity until the cancellation of the limited liability company's articles of organization. Therefore, this court concludes that Lighthouse Solutions LLC is a limited liability company and is governed by the limited liability company law. The application of the petitioner to dissolve Lighthouse as a partnership entity based upon the partnership law is denied. In the alternative, petitioner requests dissolution of Lighthouse pursuant to New York common law based upon the complete failure of the business purpose of Lighthouse and failure of the original intention of the members. The limited liability company law provides for the judicial dissolution of a limited liability company. On application by or for a member, the Supreme Court may decree dissolution of a limited liability company, and this decretal order is not reasonably practicable ordinarily to carry on the business in conformity with the Articles of Confederation or Organization or the operative agreement. decretal.
On decree. How fast was that?
I wouldn't find out, but it was pretty slow.